Good morning, and thank you for joining us for today's session on the data protection regime in the UK. I'm Richard Meehan. I'm a partner in the commercial team here at Meyerson, and I also head up our tech sector. I've been specialising in commercial law for comfortably long enough to remember the arrival of GDPR, and it has certainly been the most commonly used four-letter abbreviation I've encountered in my career. I'm joined for today's talk by my colleague Karam Bhatti, fellow member of the commercial team, who also has extensive experience in data protection. Next slide, please. Next slide, please. Data protection is one of the topics our clients most frequently want to discuss with us. And the aim of today's session is to provide a general overview of the UK data protection regime and an introduction to some of the principles and compliance areas which businesses should consider when thinking about how they collect and use personal data. As well as considering the framework and overarching principles of the data protection regime, we will look in more detail at issues commonly encountered in practice, including data subject access requests and data breaches. And we'll consider some of the specific compliance obligations imposed on businesses which handle personal data, such as carrying out data protection impact assessments and maintaining records of processing activities. The session is designed as an introduction to the topics considered, or a refresher for those with some existing familiarity with the subject, rather than a deep dive. We hope it is helpful. If you come away with questions that you would like to discuss in further detail, our contact details will be shared with everyone who has attended, and we'll be delighted to hear from you after the session. And for those who are interested in exploring the subject further, we plan to deliver future sessions where we will have the opportunity to consider some of these topics in greater depth. So please do watch this space. Next slide, please. Just before we consider the legal framework for data protection in the UK, it is worth very briefly recapping some key definitions which will recur throughout the session. As I say, this isn't a deep dive, and these are broad brush descriptions of key terms only. The term personal data itself is defined as information relating to an identified or identifiable natural person. For purposes of today's session, we will simply note that this covers a very wide range of types of data, and that the relevant individual does not need to be identified in the relevant data record. They just need to be identifiable, for example, through a unique reference code attached to the record. The individual to whom any particular personal data relates is referred to as the data subject. The concept of processing personal data is very broadly defined. It covers the collection of the data, storing it, using it, sharing it with third parties, or just making it available for third parties to access, and any other manner of dealing with the data. An organization which decides for its own purposes to collect and process personal data is referred to as the controller, while an organization which processes the personal data purely on the instructions of another organization, typically because it's acting in the role of service provider, is referred to as the processor. So turning to the data protection regime in the UK, the current, which means post-Brexit, UK data protection regime is governed by the Data Protection Act 2018 and by what is referred to as UK GDPR. UK GDPR is essentially the UK's version of the European Union's General Data Protection Regulation of 2016, the original GDPR. And it sets out the key principles, rights, and freedoms and the obligations of processors and controllers processing data in the UK. GDPR itself was the EU's effort to standardize and harmonize data protection regimes across the EU and bring them up to date with advances in technology and how businesses use data. GDPR was in effect in the UK prior to Brexit, and the Data Protection Act 2018 carried it across into UK law, subject to only minor amendments to adapt it for use in a single country and a non-EU context. It is important to note that if a business operates both in Europe and the UK, then it will need to comply with both the EU GDPR and UK GDPR. So while the regimes remain relatively consistent for the time being, it will be increasingly important for businesses which are subject to both regimes to monitor potential future divergence. One area of divergence of relevance in the UK is the Data Use and Access Act of 2025, the DUA Act, which was enacted earlier this year. And it has the aim of clarifying and simplifying the UK's data protection and privacy regime. The scope of the DUA Act is wide, and it hopes to harness the power of data for economic growth, supporting a modern digital government and improving people's lives. As we go through the session, we will pick up on some of the ways in which the DUA Act modifies the existing regime. So it's worth mentioning that most of the provisions of the DUA Act are not yet in force and will be coming into effect in stages over the coming months. A final quick point on this slide is that in the UK, the Information Commissioner's Office is currently the governing body responsible for overseeing data protection and compliance. However, the ICO is set to be dissolved under the DUA Act with a new Information Commission being formed as its replacement, and the transition is expected to take place in early 2026. Next slide, please. The 7 principles of data processing are set out in UK GDPR, and we'll consider these first. It can be tempting for businesses assessing their data protection obligations for a new project or a new venture to start from the other end of the data protection journey, essentially saying, here's what we are doing now, what are our data protection obligations? However, by bearing the data protection principles in mind from the outset, when the venture is being planned, businesses can ensure that the solutions they deliver are designed for compliance with the data protection regime in mind from the outset. The first principle of data protection states that personal data needs to be processed lawfully, fairly, and in a transparent manner. This principle requires any processing of personal data to have an established legal basis. And beyond that, the controller needs to have considered the manner in which the activity will affect data subjects. There are 6 specified lawful bases for processing, ranging from the express consent of the data subject through to processing which is necessary for the legitimate interests of the business carrying out the processing activity. Discussing lawful bases for processing could be a session in itself, but for the time being, we'll note that thinking about what the lawful basis is for each data processing activity at an early stage is important, since the choice affects what rights are available to the relevant data subject and may affect the process by which the personal data is collected. The requirement to process personal data fairly means handling it in ways that people would reasonably expect and avoiding processing activities that would have unjustified adverse effects on the data subject. And transparency means providing data subjects with information about how their personal data will be used in a way which is clear and easy to understand. The second principle refers to the purpose limitation. And the aim of this principle is to ensure that personal data is only collected for specified, explicit, and legitimate purposes. It must not be processed in a manner that is incompatible with those original purposes. And that means that as a general rule, a controller cannot use an individual's personal data for purposes other than the purpose notified to that individual at the point when their personal data was collected. Helpfully, the DUA Act does seek to add some further clarity to the purpose limitation principle and sets out conditions for further use of personal data that is deemed to be compatible with the original purpose for which it was collected. This may include disclosures for the purposes of archiving in the public interest, protecting the vital interests of data subjects and others, safeguarding children and vulnerable individuals, and complying with legal obligations. The third principle is data minimization, and this requires that personal data is adequate, relevant, and most importantly, limited to what is necessary in relation to the purposes for which it is processed. This principle means that controllers should not be collecting data for general or unspecified purposes that may arise in the future, but rather should be scrutinizing their data collection processes to ensure that only what is needed is collected in the first place. It is a principle that may gain greater attention in the context of the rise of commercial models based on big data. The fourth principle is accuracy. Personal data must be accurate and kept up to date. Every reasonable step must be taken to ensure that personal data that is inaccurate, taking into account the purpose of its processing, is either erased or rectified without delay. Fifth principle is the storage limitation, and this stipulates that data should not be kept for longer than is necessary for the purposes for which it is processed. This principle underlies the use of data retention policies within businesses, which allow the business to ensure that data is deleted once it is no longer required. The sixth principle relates to integrity and confidentiality, and this seeks to ensure that personal data is processed in a manner that provides an appropriate level of security, including protection against unauthorized or unlawful processing, which includes accidental loss, destruction, or damage. Appropriate technical or organizational measures must be implemented, and achieving compliance will typically involve ensuring that strong information security policies and procedures are in place. addressing both the technical and human aspects of ensuring data security. The final principle is the accountability principle, which makes it the obligation of the controller to ensure that the way they process data complies with the preceding 6 principles and that they have documentary evidence of compliance. Next slide, please. When we talk to clients about data protection and compliance with UK GDPR, our advice is based around ensuring that they have the necessary building blocks in place to comply with the principles we have just discussed, and in that way to achieve privacy by design. The first building block we consider is an internal-facing data protection policy. This document sets out how a business handles personal data and what it does in respect to that data, and ensures that people within the business know their own obligations in respect of keeping data safe. Next, businesses should ensure they have registered with the ICO as controllers of personal data and have paid the correct fees, which can be established using the ICO's tool. We'll talk about the importance of paying proper consideration to the retention of data and determining what the business's data retention policy was going to be at the outset. The GDPR requires a retention of data for as long as is necessary for the particular purpose for which it was originally collected. It does not specify any minimum or maximum retention periods, so it is therefore up to businesses to decide for themselves how long they should hold personal data, taking into account the purpose for which it was collected. The next building block, and one of the most important things for businesses to have in place in order to be able to demonstrate that they're complying with data protection principles, is a suitable external-facing privacy notice, or multiple privacy notices where required. An employee-facing privacy notice, for example, will be different from a customer-facing privacy notice. And by their nature, privacy notices are required to be specific, clear, and concise. So attempting to cover every circumstance where a business is collecting personal data and processing it in one policy would not be consistent with the aim of having a clear and concise privacy and privacy notice addressed to the different potential audiences. Next, it's essential to emphasize the importance of businesses ensuring the contracts they have in place with their suppliers, customers, and other third parties accurately reflect how they are handling personal data. Having the right contractual terms in place between controllers and processors, and between controllers sharing personal data between themselves, or processors and sub-processors, is a requirement of law. Moreover, collecting the information needed to populate the contract accurately enables businesses to understand who is handling the data, what data is being processed, and then to reflect in the terms of the contract the obligations that should be placed on the parties to ensure their compliance. Finally, it is important for businesses to consider whether they need to appoint a data protection officer or DPO. In certain instances, it is compulsory to appoint a DPO, for example, public authorities or private organizations whose core activities consist of large-scale processing of data or special categories of data or data relating to criminal information. DPOs are the central point of contact for all things data related in an organization. They have responsibility for overseeing a business's compliance with data protection law, as well as raising awareness within the business and advising on things such as data impact assessments. And they also cooperate with the relevant supervising authorities, in this case, the ICO. Overall, the building blocks we've discussed work to contribute to the underlying compliance concept of data protection by design. Privacy by design is intended to show that an organization has given due consideration to the data processing activities right from the outset. And when implementing methods, businesses need to take account the relevant technology available at the time, the cost of implementing those measures, the nature and scope of the processing they're going to undertake, and they need to balance that against the risk associated with a particular processing of data for the individuals affected. Next slide, please. Now that we've covered some of the underlying principles of GDPR in the UK, we will spend the rest of the session considering some practical data protection issues that can arise during a business's day-to-day operations. A very common situation is the receipt of a data subject access request, or a DSAR. Many organizations will come across them, and if you haven't, you're relatively lucky. A DSAR is a request from an individual for an organization to confirm whether it is processing that individual's personal data And if it is processing their personal data, it's a request for the individual to be provided with a copy of the personal data that's held about them. An important point for organizations to consider is to ensure that relevant personnel within the organization, which could include anyone who receives communications from outside the organization, can identify a DSAR when they receive one. This can be challenging because there is no prescribed form of DSAR, and individuals do not need to use the words data subject access request or UK GDPR or data protection law when they're communicating it to the organization. A common example of how that issue plays out in practice would be for us as a law firm. If one of our clients asks for a copy of their file, we will provide this to them, but we will also ask them to confirm whether they just want a copy of their file containing the legal work, or whether they are in fact making a data subject access request. Since if it is a data subject access request, there is a wider to do before we reply. Other potential challenges when a DSAR arrives include the scenario where one person makes a request for a DSAR on behalf of another. This is certainly possible under UK GDPR, and an individual may prefer a third party, such as a relative, a friend, or a solicitor, to make the DSAR on their behalf. However, the business receiving the DSAR must be satisfied that the third party making the request is entitled to act on behalf of the individual before it releases the information. It is the third party's responsibility to provide you as the organization with evidence of that authority. An example would be written authority signed by the individual themselves, stating that they give the third party permission to make the DSAR on their behalf. And you can accept electronically signed letters of authority as valid evidence, provided you are satisfied that the third party is authorized to act on the individual's behalf. There are other mechanisms that could allow a third party to make a request on behalf of an individual, such as a power of attorney. And again, the key will be to check the type and circumstance of the particular power of attorney to determine whether the third party is properly authorized to make the DSAR. Most powers of attorney will allow the attorney to manage financial affairs or health matters, but they may not necessarily cater for data protection, so it's important to check. If there's no evidence that a third party is authorized to act on behalf of the individual who's the subject of the DSAR, you are not required to comply with the request. However, you should still respond to them, explaining this and the reasons why you're not responding to the request. In most cases, provided you are satisfied that the third party has the appropriate authority, you can respond directly to that third party. We've set out on the slide a flowchart on how to respond to a DSAR, as it is useful to follow a methodical approach. This is a quick run through the process, and we would advise ensuring that your own internal policies and training for DSARs go into greater detail on how these steps would be managed in your business. So looking at the flowchart on the slide, as discussed already, in the first instance, when a DSAR is received, it must be established whether it's a valid DSAR request, and the business must confirm the identity of the data subject. If at that stage it's not possible to confirm the identity, the organization should request evidence of identity before proceeding to respond to the request. Once the identity of the individual has been confirmed, the business should conduct a search for all of the individual's personal data and review the contents of that personal data to determine whether all of the information collected can be disclosed. Data relating to third parties, as well as the data subject, should be anonymized or redacted as far as it relates to the third party, which can be a labor-intensive process. Once such steps have been taken, a response should be sent to the data subject. A key area where organizations can experience difficulties is relating to the timeframes, as they're relatively limited. Organizations have 1 calendar month to collate the information and send it to the individual. If you need to check an individual's ID or ask for further information, for example, to clarify whether they are in fact making a DSAR, you can wait until the response with that information is received before the clock starts ticking again for the 1 month time limit. There are a few important things, though, to remember about the 1 month time frame. Firstly, it doesn't matter if you receive the request on a non-working day. For example, if the request is made on Saturday, say the 7th of March, the response should be sent by Tuesday, the 7th of April, which can be something that organizations fail to take into account when deciding their response times. However, if the date when the response is due falls on a weekend or a public holiday, then you do have until the next working day after that to respond. You cannot add extra days to the access request when the calendar month is a short month. So if you receive a request on the 31st of January, the last day of January, you must respond by the 28th of February, being the last day of February. If the request is very complex or the individual makes a number of requests, then you may be entitled to extend the time period by an extra 2 calendar months. However, you must let the individual know that there will be delay in the response before the end of the first calendar month. And it is important to check carefully you're entitled to the additional time based on the specific circumstances. When replying to a DSAR, you should send a reply securely and keep a record of what you sent. If you receive the access request via email, then you should reply via email unless the individual has requested otherwise. And you should check generally with the data subject what format they would like to receive it in before replying. As well as providing the data subject a copy of their personal data, an organization should send its privacy information. And this is an area where organizations sometimes fall down in their response. Individuals have a right to know why you hold their personal data, how you obtained it in the first instance, and how long you're planning to keep it, who you share it with, and how they can ask for it to be changed, such as by updating their address or deleting the information. This information must be provided at the same time as their personal data. Next slide, please. So there are some circumstances where organizations can refuse to comply with the data subject access request. For example, these would include where a data subject makes a DSAR which is manifestly unfounded or excessive. Next slide, please. So in these circumstances of a manifestly unfounded or excessive request, a controller is able to charge a reasonable fee to provide the information or to take the requested action, or can refuse to act on the request. Next slide, please. Now, before doing either of those things, it's important to be very confident that the relevant exceptions apply. The ICO has published guidance on when a request might be manifestly unfounded. A request can be manifestly unfounded if the individual clearly has no intention to exercise their rights of access. For example, they've made a request and then say they'll withdraw it for some form of benefit. A request can be refused if the request is malicious in its intent and it's just being used to harass an organization with no other real purpose behind it than to cause a business disruption. This may be evidence where the individual making the request explicitly states that they intend to cause business disruption, or they're making unsubstantiated accusations against the organization or specific people within the organization, which can clearly establish malice. Further examples may be where the person making the request targets a particular individual against whom you're aware that they have some sort of personal grudge, or an individual is systematically sending you different requests with the intention of causing disruption to the business. However, you should be cautious about relying on any of these grounds to turn down a DSAR. The ICO guidance is not simply a tick box exercise, and each request really does need to be considered in its own merits and the context in which it's being made. If an individual genuinely wants to exercise their rights, then it will be extremely unlikely that the request being made is manifestly unfounded. A DSAR may contain aggressive or abusive language. While this is not necessarily acceptable, it does not mean that the request is manifestly unfounded and cannot be used as a grounds in itself for turning down the DSAR. Next slide, please. When considering if a request is manifestly excessive as opposed to unfounded, businesses again need to consider whether the request is so clearly or obviously unreasonable and this means the business needs to consider whether the request is proportionate when balanced against the burden of the cost of the business of complying with the request. When determining if a request is manifestly excessive, a business should consider the nature of the requested information, the context of the request, and the relationship between the organization and the individual, whether a refusal could cause substantive damage to the individual, the available resources of the organization, and whether the request is repetitive or overlaps with other requests. An important point to note, though, is that just because a request would involve a large amount of data being provided to the individual, this does not mean that the request is manifestly excessive in itself. As a general approach, when a business is determining whether to respond to a data subject access request on the basis that it's manifestly unfounded or manifestly excessive, take account of each request on its individual merits and don't assume that a request is manifestly unfounded or excessive just because the individual has previously submitted requests that were manifestly unfounded or excessive in themselves, and the new request may be acceptable. And inclusion of the word manifestly here means that there must be an obvious and clear quality. So you need to ensure that if you do decide not to comply with the request on these bases, that you have strong justification why you're not complying and evidence to back it up. Some common examples we see of requests that are unfounded or excessive tend to arise in situations where there is a disgruntled employee or someone who has left a business on a sour note and may be seeking to cause disruption. So these are circumstances where a business may want to be more alert and think about using their ability to refuse to comply with the DSAR. Next slide, please. There are some further exemptions to the right of access other than where the request is manifestly unfounded or excessive. These exemptions relate primarily to the detection of crime, immigration control, or in relation to legal proceedings. They're not particularly relevant for private organizations generally, and in turn, we're not going to cover them in detail in this session. Next slide, please. Our final slide on this simply summarizes some key points on the processes that an organization can take in preparing to comply with DSARs. And I'll also draw attention to further helpful guidance available on the ICO website. You're considering your processes for compliance with DSARs. Next slide, please. Our next topic for the session is the topic of personal data breaches. Next slide, please. A personal data breach is a breach of security that leads to the accidental or unlawful destruction, loss, alteration, or the unauthorized disclosure of or access to personal data. This includes breaches that are both accidental and those which are deliberate. It means that a breach is more than simply losing personal data. It covers cybersecurity incidents as well, of the kind which are becoming increasingly common. We've set out on this slide some outline steps that can assist if an organization is subject to a personal data breach. The first step is to act quickly and decisively to establish whether there has been a personal data breach, and if so, what steps are necessary to address it. A breach can have a range of adverse effects on individuals. It can include things such as emotional distress, as well as resulting in physical or material damage to the individual. Not all breaches will lead to risks to an individual that go beyond a mere inconvenience or annoyance, but those that do can have great consequence. Businesses must be mindful of the facts that breaches can have a significant effect on the individuals whose personal data has been compromised. So if you become aware that your business has been subject to a data breach, the necessary steps to contain it are essential, as well as an assessment of the potential adverse consequences. How serious and substantial the consequences are will determine the next steps that need to be taken. The second step in the checklist is to notify the ICO if the breach is one that is required to be notified. The threshold for notifying the ICO is lower than the threshold at which it becomes necessary to notify the affected data subjects themselves. If the data breach is likely to give rise to a risk of harm for any individual affected, then the ICO does need to be notified. However, if the consequences of the breach do not pose a high risk to the individual, then it may not be required to notify that individual themselves on top of the ICO notification. Notifiable breaches should be reported to the ICO without undue delay and must be reported within 72 hours of the organization becoming aware of the breach. The third step in the checklist is assessing when to notify the individuals concerned. And it must be assessed whether the breach is likely to result in a high risk to the affected individual's rights and freedoms. If so, the individuals must be notified without undue delay. Businesses will need to assess the severity of the potential for or actual impact on the individual and the likelihood of the harm occurring in respect of the individual. If the consequences of the breach are likely to arise and likely to have a high risk impact on the individual's rights and freedoms, then the affected individuals will need to be informed, particularly if they will need to take steps to mitigate an immediate risk of damage to them. For example, if it was personal data relating to the banking information of the individual, they'd need to be able to inform their bank of the breach and be alert to suspect transactions on their accounts. Step 4 in this checklist is something the organization must do for all data breaches, irrespective of whether they need to be reported to the ICO or the individual. and that is to keep a record of the breach. A data breach register is where this information can be documented, and it's important to record the circumstances surrounding the breach, the effects of the breach, and any remedial action that the business took. Again, this is part of the business's overall obligation to comply with the accountability principle under the data protection regime. And it's also a useful tool for the business to be able to review periodically in order to understand if there are any trends or patterns emerging within the business and what steps the business can take to prevent the issue recurring. If a breach does occur, the business should note that the ICO has the power to impose substantial fines. As we noted earlier, these fines could extend to the greater of 17.5 million or 4% of annual global turnover. These are, of course, maximums, and the general level of fine issued by the ICO is far lower, but still painful for the businesses affected. Next slide, please. Some points to consider when addressing common reasons for breaches include those discussed on this slide. As these topics indicate, staff training is key. It is essential to ensure staff are aware of the data they are handling and how they can protect this data from breach. Many instances of personal data breach stem from human error, so providing regular training on how to assess potential attacks, such as phishing emails or other scams, is essential, as these attempts to gain personal data from a business become more sophisticated. Another essential layer of protection is implementing policies that ensure work devices that employees may be taking home are password protected, and passwords are not duplicated between numerous work devices. Beyond those in-house measures that can be implemented, there are also external accreditation schemes to assess the general security of business infrastructure and IT security, such as the Cyber Essentials accreditation and ISO accreditations. And these can be useful when assessing the strength of protections that a business's systems have against the risk of data leaks and cyber attacks, and also with implementing measures to improve resilience. With that, I'll now hand over to Karam to discuss the remaining areas of data protection compliance covered in today's talk.
Thank you, Richard. So just by way of an introduction, my name is Karam and I'm an associate within the commercial team here at Meyerson, and I'll be talking to you today about data protection impact assessments, or DPIAs, and maintaining data processing records, both of which play a core part in demonstrating compliance with the accountability principle, which my colleague Richard touched on earlier. Next slide, please. So what are DPIAs? Well, DPIAs are probably one of the more lesser known legal requirements prescribed by the UK GDPR. And in a nutshell, a DPIA is essentially a process that's designed to help organizations to analyze, identify, and minimize the data protection risks of a specific project, which generally takes the form of a written record. So why DPIAs so important? Well, they're important because, firstly, conducting DPIAs is a legal requirement under UK GDPR, and carrying them out plays a key part of demonstrating an organization's compliance with the accountability obligations prescribed under UK GDPR. And secondly, a failure to carry out DPIAs when required to do so can leave organizations open to enforcement action by the ICO, and that includes fines of up to 8.7 million or 2% of global annual turnover, whichever is greater. So in general, consistent uses of DPIAs will increase the awareness of privacy and data protection issues within an organization, and also help to ensure that all relevant staff involved in the designing projects think about privacy at an early stage and adopt a privacy by design approach. DPIAs also bring wider compliance benefits, as it can be an effective way to assess and demonstrate the compliance with all data protection principles and obligations. Notwithstanding this, DPIAs are not just a compliance exercise. An effective DPIA will also allow you to identify and fix problems at an early stage, bringing broader benefits for both individuals and your organization. So who should carry out DPIAs? Well, Article 35.1 of the UK GDPR confirms that DPIA should be carried out by controllers who utilize a type of processing which is likely to result in a high risk to the rights and freedoms of individuals. Now, although high risk is not defined in the UK GDPR, this should be taken as referring to the risks to individuals' interests and any potential harm, and that includes non-tangible harm such as significant economic or social disadvantage. If it's unclear, as to whether processing is high risk, it's recommended that a DPIA is still carried out regardless. And the ICO guidance confirms this, stating that it's good practice to undertake a DPIA for any major project involving the use of personal data. Helpfully, the ICO has published a really useful list of high-risk types of processing which would merit a DPIA be conducted. Now, I won't go through every single one of these in detail, but some of the key examples include any processing activities which involves the use of innovative technologies such as AI, any processing of sensitive personal data such as health, genetic or biometric data, or data relating to children or vulnerable adults, or the carrying out of large-scale processing, taking into account the number of individuals concerned, the volume and variety of data, the duration of processing, and the geographical extent of the processing. Now, it's important to bear in mind that some of these operations require a DPIA automatically, and some of them only require them when they occur in combination with one of the other items. Next slide, please. So how should a DPIA be carried out? So firstly, touching on timing, in order to comply with the UK GDPR, the DPIA should begin as early as possible, and where processing operations are subject to ongoing changes, the DPIA may need to be continuously updated to ensure that the relevant requirements of UK GDPR are complied with. Secondly, what form should a DPIA take? Now, it doesn't need to follow any prescribed form, and the UK GDPR provides flexibility for data controllers to determine the precise structure and form of the DPIA. Now, notwithstanding that there's no single format or structure that must be followed, Article 35(7) of the UK GDPR sets out that as a minimum, DPIA should include the following elements. So firstly, a systematic description of the proposed processing operations, the purposes of the processing, an assessment of the necessity and proportionality of the processing, an assessment of the risks to the rights and freedoms of data subjects, and the measures envisioned to address these risks. And these may include safeguards, security measures, and other mechanisms to ensure the protection of personal data. I suppose you might be thinking, well, that's great, we've documented all of that. Well, that's just going to be another record that we're going to keep within our business, and who's ever going to actually, ask to have sight of it? Well, aside from the ICO acting as the independent body regulating data protection compliance in the UK, we are starting to see more and more third parties requesting sight of DPIAs, and that can include in the context of a sale of a business, specifically during the due diligence phase, where we're seeing more and more buyers requesting evidence of data protection compliance. And the lack of such documentation can result in the request for sellers to provide specific warranties and indemnities in respect of data protection compliance. In addition to this, customers or clients who may request sight of a DPIA as part of their own internal due diligence to ensure they're engaging with and utilizing suppliers who are UK GDPR compliant. So that covers the section on DPIAs. I'll now move on to talk about another key area of compliance under the UK GDPR, and that's maintaining records of data processing activities. Next slide, please. So again, this obligation to maintain records of data processing activities is a legal obligation set out in the UK GDPR, which confirms that both controllers and processors must maintain that record. So who does the obligation apply to? Well, the UK GDPR confirms that the record keeping obligation only applies to organisations with 250 or more employees. Now, it's vital to note that the UK GDPR provides a limited exemption to this, confirming that small and medium-sized organisations, so those employing fewer than 250 employees, must comply with such obligations where their processing activities are not occasional. So, for example, they are more than just a one-off occurrence, where their processing activities are likely to result in a risk to the rights and freedoms of individuals. So, for example, something that may be intrusive or which may adversely affect individuals, or where their processing activities involve special category data or data relating to criminal convictions and offences. So just by way of a worked example, let's presume we have a small insurance company employing 50 members of staff, which regularly processes personal data in the context of processing claims. Now, although the company has fewer than 250 employees, it must still document these types of processing activities because they are not just occasional. Let's say the same company carries out several other processing activities such as profiling on its customer database for the purpose of insurance risk classification. Again, the company must still document this, as profiling can be intrusive and may result in risks to individuals' rights and freedoms. Finally, let's say the insurance company carries out recruitment campaigns from time to time, during which it collects data relating to applicants' health and ethnic origin. Again, the company must still document these processing activities because it involves the processing of special category data. So as you can see, this exemption is likely to catch a very high percentage of organisations operating within the UK. And even if an organisation found itself outside of the scope of this exemption, it would still be prudent and worthwhile investment of time to do so, as keeping records on what personal data you hold, why you hold it, and who you share it with can provide organisations with really a wide variety of benefits, including improved data governance, enhanced data security, more efficient operations, more informed decision making in relation to data related matters, and also supporting compliance with other obligations under the UK GDPR. And similar to DPIAs in terms of third parties who may request sight of such records, obviously the ICO can request a copy to ensure organisations are complying with their relevant obligations. And also, again, in the context of business sales, we are seeing more and more buyers requesting sights of such records. Next slide, please. So how should an organisation go about producing such records and what must be included? In terms of initial steps, a good way to start is by doing an information audit or data mapping exercise to clarify what personal data your organisation holds and where. This could consist of A, devising and distributing a questionnaire to the areas of the organisation which process personal data, B, meeting directly with key business functions to understand how they use data, and C, reviewing policies, procedures, contracts, and agreements. For example, privacy policies, data protection policies, data processor contracts, and data sharing agreements. Once you have a basic idea of these elements, you'll be in an informed position to begin documenting the information. Now, the UK GDPR is very prescriptive in terms of what needs to be included, and this varies slightly depending upon whether you're acting in the capacity as a controller or processor. I'll run through what needs to be included within a record where an organisation is acting in the capacity as a controller, as the requirements for controllers are slightly more extensive than for processors. So firstly, the organisation's name and contact details. Where applicable, the name and contact details of any appointed data protection officer and any joint controllers. The purpose of the processing, so why you're using the personal data. For example, that may be customer management, marketing, or recruitment. The categories of individuals, so the different types of people whose personal data is being processed. So that could be employees, customers, members. The categories of personal data, so the different types of information you process about people, for example, contact details, financial information, or health data. The categories of recipients, or anyone you share that personal data with, for example, suppliers or credit reference agencies. Where applicable, the name of any third-party countries or international organizations that you transfer personal data to. So that's any country or organization outside of the UK, including details of the safeguards utilized to secure such transfer. Retention schedules for the different categories of personal data and confirming how long you will keep that data for. And a general description of your technical and organizational security measures. So essentially your safeguards for protecting personal data, which could be encryption or access controls. I'll just end this segment on an important point to note, which is that keeping records of your processing activities is not just a one-off exercise. The information you document must reflect the current situation as regards the processing of personal data. So the record should be treated as a living document, which you update as and when necessary, meaning you should conduct regular reviews of the information you process to ensure your documentation remains accurate and up to date. So just to summarize, next slide, please. So just to summarize and recap, this webinar has essentially been a whistle-stop tour of the data protection regime in the UK, touching on some of the really key areas, such as the principles underpinning data processing, subject access requests, and managing personal data breaches, outlining some of those really key actions which organisations should take and considerations in such circumstances. DPIAs and looking at when organisations should consider conducting these, and finally maintaining data processing records and the benefits of which maintaining such records can offer organisations. So that concludes today's webinar. I'll just finish by saying a thank you from myself and Richard for joining us today. We hope that you found the webinar helpful and informative. Our contact details will be shared shortly, so please do get in contact with us if you have any data protection related queries or questions. Thank you.